नमस्कार, आदाब, सत श्री अकाल दोस्तों। स्वागत है आपका एक बार फिर से हमारे YouTube चैनल ब्रास फ्यूजन्स पर, जहां हम आपके लिए एक बार फिर से लेकर आए हैं एक नया लेसन।
Talk about different aspects of private international law disputes. We started our discussion with a very specific aspect, and that is every private international law dispute will have foreign element. Can you hear me?
Yes, sir.
Okay. Thank you. Hey, good morning. Yeah. All right. So then we move ahead and talked about the definition of private international law, and we saw as to how different elements of the definition of private international law are placed. We further talked about in the initial lectures about the different stages of a private international law dispute. Now, once we covered all these aspects, we subsequently moved on to identify the reasons for private international law and why do we need something called private international law rules. Now, in that regard, we focused on a few specific reasons while identifying the distinct nature of private international law dispute. Now, these reasons are that if we apply the domestic law in a dispute involving foreign element invariably, then this might lead to injustice, and we explained as to what conditions this injustice. The second thing is that it might also change the legal status of parties considerably. Further, we talked about the idea of Committee of Nations as the basis of private international law dispute. Now, we saw that while Committee of Nations is generally identified as the basis of a private international law dispute, however, Cheshire seems to disagree with many who argue that private international law or Committee of Nations is the basis of private international law dispute. Subsequently, we also tried to talk about the idea of space and time in relation to private international law dispute. Our argument was that how private international law is significantly different than other laws when it comes to the idea of space and time, and how it breaches the conventional boundary of the application of laws in a given space and time. Further, we talked about the unification efforts in relation to private international law dispute. So we say that how, for example, when it comes to private international law rules, there are different kinds of unification exercises which seems to be happening. Now, these primarily relate to, say, how different rules of private international law are placed, and that few bodies who particularly engage in such a task, UNID, Royat, UNCITRAL, and Hague Conference on Private International Law, a few of them. We further saw that how within Europe, and particularly European Union, the unification exercise seems to have taken a far more sophisticated turn, and the unification among the private international law rules of European nations are better than how these rules are placed in relation to other countries. We further talked about the name of the subject, that is private international law. We saw as to how the name private international law is open to different forms of criticisms. Those who disagree with this name private international law, they propose another term called conflict of laws. But conflict of laws as a term is also open to similar criticisms, and therefore there is no term which comprehensively covers the essence of the subject. But these two are the names which are often invoked in relation to private international law, in relation to private international law rules, and therefore these two terms have acquired a qualified, or for example, or for that matter, an advanced understanding that whenever we refer to, say, private international law or conflict of laws, these terms are so well known that it is understood by those who engage with the subject that we are referring to a particular body of law. Now, having done this in the first week or so, then we moved on to identify and study different stages of private international law dispute. Now, in that regard, we saw that how the question of jurisdiction is placed. We further saw that how applicable law is to be identified, and then recognition and enforcement of foreign judgment is the third stage. We are at the first stage where we were talking about the issue of jurisdiction. In terms of talking about the issue of jurisdiction, we saw that how there could be different approaches to study the question of jurisdiction. We further talked about the general notions of jurisdiction as to what is the concept of jurisdiction, how does public international law conceptualize the issue of jurisdiction, maybe exception to a general jurisdictional debate, and how we tried to talk about universal jurisdiction there. We further tried to advance or we further try to explain the distinction between a purely local matter and a transnational matter. And we saw that how private international law or a transnational matter is different from a purely local matter in which certain kinds of jurisdiction are invoked. So the method of invoking or the framework of invoking jurisdiction in a purely local matter is significant, is different from how jurisdiction is to be invoked in transnational matters. That's one. What we further talked about is the connection idea, that every form of jurisdiction should be based on some rationality or some form of rationality. There should be some basis of jurisdiction. Now, this basis can be found in, say, a number of aspects, say domicile, residence, nationality, presence, similarly the place where you are doing business or you are engaged in a particular act. So all these factors might determine how the jurisdiction is established. But then we came to a much more concrete discussion, and the discussion was that how does it actually work within the laws in India? Now, different laws have different jurisdictional clauses. When it comes to the most general law dealing with the issue of jurisdiction, is something called Code of Civil Procedure. When it comes to the jurisdiction over civil matters. Now, one of the questions which will come to, or which comes to our mind, is that who may file a suit? Now, in such a situation, the question as to who will file a suit necessarily brings to limelight alien enemies, and whether alien enemies can file a suit or not. And we had a long discussion, at least in the first lecture, in the last lecture, with the help of 3 cases as to the situations in which alien enemies can file a suit. And more importantly, who are alien enemies in the first place. So with the help of the 3 cases, that is Firoza Begum versus Diwan Daulat Rai Kapoor, Prem Pratap Singh versus Jagat Pratap Kumar, and Sita Lakshmi Achi versus V.T. Virappa Chetiyar, we try to understand the law relating to the determination of alien enemy status and what are the restrictions on alien enemy. Now, to put it in very, very simple sense and very briefly, maybe missing on a number of points, the first argument would be, or the first point would be that alien enemies within common law system is identified. I mean, they're identified in relation to their residence and not nationality. It is important to see whether on the date of the suit they were alien enemies or not. If subsequently their status have changed, that will not affect or that will not trigger Section 83. What is important is that on the date of filing of suit, whether they were alien enemies or not. Now, if the status changes subsequently while the proceeding is going on, or for example, while the matter is pending before the court, in such a situation, Section 83 will not be triggered. So this is the point which can be broadly identified as emerging from these 3 cases. There were a number of points. We spent one entire lecture on that. So I hope some of you, at least those of you who attended the lecture might be able to recall it. Very briefly, what we did yesterday was to talk about when foreign state may sue. We also talked about the aspect of immunity, and we saw as to how certain individuals and entities are immune from getting sued in Indian courts by virtue of Section 86. Now, this is fundamentally resulting from how the concept of immunity is placed under international law. Immunities, or the idea of immunities under international law, is based on this principle called principle of reciprocity. Although Section 86 does not directly invoke principle of reciprocity, but the idea of diplomatic immunities, or the idea of immunities in general, diplomatic consular immunities, head of the state immunity, foreign state immunity, all these ideas are fundamentally based on the principle of reciprocity. Although Section 86 does not mention principle of reciprocity, and therefore in its application, reciprocity is not one of the criteria. But at its core, in principle, in theory, it is based on reciprocity, among other things. Very briefly, let me finish this aspect, and then I would like to get into something concrete. I mean, not that this is not concrete, but maybe move further with conflict-related issues. Now, when it comes to Section 16 of CPC, now what would happen in relation to, say, immovable property? In relation to immovable property, the place where the property is situated, the forum of that place exercises jurisdiction. This is something which we must remember. The forum of the place where the property is situated generally exercises jurisdiction in relation to immovable property. This is reflected in Section 16 of a Code of Civil Procedure. Something very obvious, and this principle which looks very obvious, and which of course is very obvious, and it is accepted as part of most of the legal systems. Now, this principle came before, or was emphasized by the Supreme Court in a case called Nachappa Chetiyar versus Subramamma Chetiyar. Now, in this case, basically, we were dealing with a situation where the question was with regard to division of a property situated in Burma, which is currently known as Myanmar. Now, the issue which came before the court was whether Indian courts have jurisdiction to determine the question of title in respect of the property which is based in Burma, again, a foreign country. And court said that Indian courts have no jurisdiction to determine the questions of title in respect of movable properties in foreign countries. Court went further and drew a larger conclusion out of it. Then court said that since we have no jurisdiction to determine, say, any controversy or dispute relating to the question of title regarding an immovable property based in foreign country, therefore we cannot even refer the matter to arbitration. Through arbitration the matter should be solved. It said that since we do not have jurisdiction, we cannot carve out any further legal obligation out of it. Now, what happens with regard to movable property? In a very basic form, maybe when it comes to wrong done to a movable property, then suit can be filed at the option of the plaintiff in either the court where that harm was done, or for example, where the defendant actually resides or carries on business or personally works for gain. So where the defendant resides, or where the harm to the movable property was done. Now, this is how the aspect of movable property can be understood. Now, other suits are fundamentally in relation to other suit. Fundamentally, the jurisdiction is decided in relation to where defendants reside in a very similar way, or where cause of action arises. Now, this is how roughly Code of Civil Procedure tries to talk about the issue of jurisdiction. So what we have seen is that we refer to Section 83, we refer in relation to alien enemy, we refer to Section 86 in relation to immunities regarding certain entities. We further refer to Section 16 for immovable property, we refer to Section 19 for movable property, and then we refer to Section 20. Now, this is a broad framework of jurisdiction. As I said in one of the initial lectures, that different laws have different provisions and different aspects regarding jurisdiction. So, for example, different personal laws might have its own terms of jurisdiction, or might have their own jurisdictional clause, to put it in technical words. And therefore, when it comes to such laws, a separate examination has to be done, that there is a jurisdictional clause in a different statute, and that jurisdictional clause would apply in relation to a dispute involving foreign element. Similarly, when it comes to, say, Guardians and Wards Act, and how do we decide the issue of guardianship of a child, for example. Now, in such a situation, the defining criteria is the place where the minor whose guardianship is in question, say the place where that minor ordinarily resides, the place of that particular, the forum of that particular place rather will have jurisdiction. This is provided under Section 9. The point which I'm trying to make, apart from these specific explanation to different sections, is that there could be different ways of examining the issue of jurisdiction. There could be different ways of looking at the question of jurisdiction based on specific laws in sectoral areas. As I said, for personal laws, there could be one form. For movable property, there could be another form of jurisdiction. For immovable property, there could be another form of jurisdiction. So the question of jurisdiction varies according to the subject matter at hand. And of course, the legal system which we are talking about. So the laws which are there in India with regard to jurisdiction, and that too regarding specific subject matter, might not replicate the laws of other legal systems like, say, US, Canada, Brazil. So these laws differ. So there's a diversity of rules when it comes to the question of jurisdiction. Now this brings me to a bit complicated question, in fact. And the complicated question is this: that what would happen in a scenario where two courts have jurisdiction? There is every possibility in a private international law dispute. This is a good possibility, rather, in a private international law dispute, that two courts might have jurisdiction to try the same matter between the same parties having a foreign element. Now, in such a situation, should the Indian court exercise jurisdiction over a dispute? Let me rephrase it. Now, if a foreign court can also exercise jurisdiction, and to complicate the situation, just imagine that foreign court is better placed to exercise jurisdiction and resolve the dispute. Should an Indian court exercise jurisdiction over that dispute or not? This could be one question which we'll try to solve today. The second question which we can try to solve today is that what should happen if proceedings are or might be commenced in both the courts, say the foreign court and in the Indian court? What would happen in such a situation? As I said, in private international law dispute, there is every possibility that two courts might have jurisdiction, or there is a good possibility rather that two courts might have jurisdiction. Now, for that, for example, the law of one country says that the nationality of a person would decide whether the court will exercise jurisdiction in relation to, say, matrimonial issues. The law of another country says that no, the domicile of a person would decide whether the court will have jurisdiction or not. Now, the case can be filed in both the forums if, for example, the person is a national of one country, but he holds a domicile of another country, which according to the law is very much a possibility, which is a very common kind of problems which we have in private international law matters. What would happen in such a situation? Now, the problem is that both the courts can exercise jurisdiction. But imagine the Indian court believes that the foreign court is better suited to try the matter. But does that mean that Indian court will not look into the matter? Now, these are the questions we are going to address today, and we are going to find an answer to these questions. Now, the questions which I just posed, now it brings to the fore at least three different ideas. One idea is often termed as forum shopping. And we are going to talk about this idea as to what do we mean by forum shopping. The second idea is forum non-convenience. And the third idea is anti-suit injunction. So we are going to talk about all these three ideas. And with the help of all these three ideas, we are going to solve the problem which I just identified. I hope the problem is clear, right? I mean, any questions? Have you understood the question which we just posed? No, yes. Okay, thank you. All right. Now, what do we mean by forum shopping? Now, just imagine, let's have a general situation first. Now, imagine that both the plaintiff and the defendant, they agreed that yes, the court of one country should have jurisdiction. Say the Indian court should have jurisdiction in relation to the dispute at hand. They come to India. Now, two courts had jurisdiction in relation to a particular matter, but both the plaintiff and the defendant, they decide that no, let's go to the Indian courts to solve our dispute. Now, that's a relatively simpler case where both the parties have agreed to the jurisdiction of one court despite different forums having jurisdiction. So they file case so plaintiff files case in one court, the defendant of course agrees to contest that particular matter in the same forum. Now here the issue of jurisdiction is less complicated. Now, court just has to tick the box. Maybe one of the sections should be satisfied, which we just read. If the question, for example, is with regard to movable property, it has to be seen whether the movable property is in. If the question is with regard to immovable property, the issue or the question which has to be solved is that whether the immovable property is situated in India or not. If it is situated in India, fine. Court will say that both the parties agree thereto. Now we can exercise the matter. We can go ahead. Many a times in contractual matters, what happens is that there is something called jurisdictional clause. So when a contract is prepared between the two parties or two or more parties, there is a jurisdictional clause. What do I mean by jurisdictional clause? Jurisdictional clause would basically prescribe that if at all there is a dispute arising from this contract, and it will identify what kind of dispute is it actually talking about, then the jurisdiction might lie with, say, Delhi High Court, or for example, some other court, or the court in Brazil, or for example, the court in South Africa. So it identifies a particular subject, a particular forum to solve the dispute. Now you might have seen such contracts. You might have actually signed such contracts in relation to a purely domestic matter. That if at all there is a problem, the matter would be heard by such and such courts. These are simple issues. But imagine that where jurisdiction or the parties disagree on the fact that, or the parties don't want to appear before one forum. There are two different forums, and the plaintiff has the option to approach any one of those two forums. So the plaintiff can either go to say how a forum in Brazil is placed, or they can file a suit in India. Now, plaintiff can make an examination, or plaintiff can make a determination that if a suit is filed in Brazil, then it might benefit me in terms of compensation, in terms of other aspects, especially, for example, how it might be more troublesome for defendant to travel to, say, Brazil and defend himself or herself. Now, based on such assessment, if the plaintiff comes to an outcome that a Brazilian forum would lead to or might lead to a more favorable outcome, plaintiff goes to Brazilian forum instead of India. Now, this phenomena or such kind of practice is termed as forum shopping. So, forum shopping is basically, to put it in simple words, forum shopping is a practice basically where a party makes different kinds of analysis, gives a different kinds of assessment in relation to different forums it might have jurisdiction over, and then decide that one forum is more likely to provide a favorable outcome, and therefore that party goes to that particular forum. This is forum shopping. It is generally considered as problematic. It is considered as deeply problematic, and therefore a number of tools have been devised to counter this practice of forum shopping. So, few tools which is identified as common law is something which we are going to study today. So, what we are going to talk about subsequently in this lecture is the concept of forum non-convenience and anti-suit injunction. Now, when it comes to forum non-convenience, what is it that we are talking about? A forum non-convenience is a Latin phrase which is translated as inconvenient forum. Now, forum non-convenience or inconvenient forum, as it can be translated as, would basically mean that it allows a court to dismiss a suit where the court considers that, say, there is a more appropriate forum or more convenient forum to try that particular matter. Now, let me explain this point. Just imagine the matter is before an Indian court. And when the matter is before Indian court, there's an argument by the defendant that, there is another forum which is better suited to try the matter. It's not that the Indian courts don't have jurisdiction. Indian courts might have jurisdiction in relation to the subject matter at hand and between the same state party. The defendant makes an argument, but there is another forum which is better suited. And we'll come to this aspect as to what we mean by better suited. Or more appropriate. So we'll come to this aspect as to what we mean by more appropriate. More appropriate forum, so to say, try the matter at hand. In such a situation, court can dismiss a suit or, for example, stay a suit and ask the plaintiff to approach the other forum which it considers to be more appropriate or convenient forum to try the matter. Now, let me put it in very, very simple and sequential sense rather. So the basic principle of forum non-convenience is that a stay will be granted on a suit which is lying before a court on the ground of forum non-convenience, where the court where the suit is lying is satisfied that there is some other forum which is available and which has jurisdiction and is better suited, is more appropriate forum to try that particular matter or to decide that particular matter. This is known as forum non-convenience. That the present forum is an inconvenient forum. Now, many a times you'll also come across a term called forum convenience, where there are two or more forums and a charge is met that the other forum is more convenient forum. Court will get into this exercise of identifying the appropriate forum, and court might conclude that no, the present forum is the convenient forum to try the matter. It's a typical example of how forum convenience is placed. Now, if you have understood what I just explained regarding forum non-convenience, the first question which might have come to your mind is, what is this appropriate forum? What is it that you are referring to in terms of something being an appropriate forum? Now, what I mean by appropriate forum, there cannot be a definite understanding of appropriate forum, which has to be determined in accordance with the facts, issues, and circumstances of each and every case. However, what I mean by appropriate forum is a forum in which the case may be tried more suitably for the interest of all the parties and, say, for the interest of justice. Again, these are vague terms. You say that fine, more suitably for the interest of all the parties and interest of justice. It has to be much more precise. I'm sure that is a question which might be coming into your mind. Now, there are different terms which are used in relation to appropriate forum. So many a times the term appropriate forum is also known as natural forum, or the term appropriate forum is also seen as leading to a test, and the test is known as real and substantial connection test. So what has to be seen is that whether the country, whether the forum has a connection with the country where in relation to which the action arose, and whether this connection is most real and substantial in a purely relative sense. So there are different terms which are invoked for it. One, natural forum. Another, real and substantial connection. As I said, there is not a definite test to identify appropriate forum, but certain factors are taken into consideration. These factors are not hard and fast factors. These are loosely mentioned factors rather, to identify whether something is an appropriate forum or not. Now, what are these factors? These factors are, say, that in the two forums which we have, access to evidence in one of the forum is more easy, for example. That's one example of a factor which has to be taken into consideration while deciding this particular issue of forum non-convenience. Similarly, where the interest of the two parties differ in connection with the respective forum. So court will take into consideration that factor that, if a case is filed in this forum, then it will benefit one party. And if the case is filed in another forum, it might benefit another party. So court will try to get into the degree of benefit which a party enjoys in relation to different forums. Similarly, court will also take into consideration that if a particular suit is maintained here, whether it would be more burdensome, more problematic, more difficult for defendant to defend himself in that suit. Court will also take into consideration other ancillary issues. So, for example, if a witness has to be brought in, whether it would be convenient for him, whether that forum would be a better place for witnesses. And lastly, and in fact, a very important criteria in deciding forum non-convenience could be enforceability of a judgment. So that fine, even if Indian courts pronounce the judgment, how will that judgment be enforced in some other country? Or if there are two courts having jurisdiction, and one is an Indian court and the other is a Brazilian court. Now, the judgment has to be enforced in Brazil, for example. Then the question which arises is this, that how does, or the consideration which comes into picture is this, that it's better if Brazilian court exercise jurisdiction, because then the factor of enforceability would be better explained, or enforceability of the judgment would become easier. So this is another factor which is taken into consideration while determining the appropriate forum criteria. I hope you are following the discussion, right? I hope everything is fine. No, yes. All right. Now, this is how forum non-convenience is placed. Now, there's something called anti-suit injunction. This is another idea which I would like to invoke in the class today. Now, what is anti-suit injunction? Now, anti-suit injunction is basically a court order. Like any other court order, it is also a court order. But this court order fundamentally prevents an opposing party from commencing or say continuing a proceeding in another jurisdiction or forum. Let me explain this point. Let's take the same example where Indian courts have jurisdiction and where Brazilian court has jurisdiction. Now, the plaintiff files a suit in Indian court and fearing that the defendant, just to complicate the situation and delay the matter, might file another suit in Brazilian court. What plaintiff might do is to appear before the court and say that issue or grant an anti-suit injunction. Now, by virtue of this anti-suit injunction, the defendant or the opposing party would be prevented from, say, starting a proceedings in another jurisdiction or court. Similarly, if the matter is already going on in the another court and the matter is also going on in this court, and the court decides that this is the appropriate forum, the forum which is actually looking into the matter is the appropriate forum, then court may also issue anti-suit injunction, basically preventing the other party from continuing with a proceeding in the foreign court. This is known as anti-suit injunction. Now, subsequently, the question which arises, and the question which should trouble us, is that what are the factors which are taken into consideration while issuing anti-suit injunction? Now, there's a very famous case called Modi Entertainment Network versus WSG Cricket Private Limited. This is a Supreme Court of India judgment in 2003. Now, in this judgment, court identified the factors which are to be taken into consideration while issuing or while granting anti-suit injunction. What we are going to do as part of our discussion is to have a look at this specific these specific factors which are taken into consideration. Now, I think I've received some requests regarding the link for the class. Now, if any one of you want to want the link of the class, it's better if you get your name added to the mailing list which I have. So if you want the class links, I'm perfectly fine with that. Just send your email ID, the EU official email ID, and then your name could be added to the mailing list, or you can become part of that classroom, that group which you have, the Google Classroom, and then you'll get all the information, because sending links every day might be inconvenient for both of us, in the sense that you might have to remind me every day, and then I will have to send it even during the classrooms. I hope that is fine. That would be better for both of us, I guess. So, all right. Now, what we... Yes.
Can you take it? Can we take it as a fact that before even considering anti-suit injunction proceedings, a court will necessarily come to decide the question of jurisdiction? Like, it will recognize and identify its jurisdiction before going into question of whether we should grant an injunction, this anti-suit injunction or not.
Yeah. Oh, that's a good question. Yeah. So at least the answer to it seems to be in affirmative, that yes, court will first satisfy that whether it has jurisdiction or not. Only then it can stop someone else to exercise jurisdiction, isn't it? So only if the court considers that yes, it can decide the matter at hand, only then it will issue, say, an anti-suit injunction asking the defendant not to appear before the other party, or maybe to stop, or for example, preventing the opposing party from continuing or commencing with a particular suit in another country. So the logical answer to your question seems to be yes. The court should be satisfied with the idea that it has jurisdiction before it gets into one of these exercises. Anti-suit injunction being one of them.
Thank you, sir.
Yeah. Now, there's this another question. Okay, I hope you got the case. Can you see the case here? Yeah, it's there in the chat box.
Yes, sir. Got it.
Yeah. Now, what we are going to do is to talk about different factors which are to be taken into consideration while granting anti-suit injunction. Now, the first factor which the court identified, the Supreme Court of India identified in terms of a factor to be considered before granting anti-suit injunction is that the court should be satisfied that the defendant is amenable to the personal jurisdiction of the court. To put it in other words, that the defendant is capable of being acted on by the court. Now, this needs a bit of an explanation, a minor explanation. When we say personal jurisdiction of the court, I have explained this part in one of the initial lectures, that when we say personal jurisdiction of the court, such form of jurisdiction, in such a situation, court will first determine which is the appropriate forum, having regard to, say, the convenience of the parties. And after taking into consideration all these factors, it may grant anti-suit injunction in relation to the proceedings which are oppressive or vexatious. To put it in other words, that court convenient forum or not. If it is a convenient forum and the other forum is not the convenient forum, then it may grant have been made in the jurisdictional clauses is not a determinative proof of jurisdiction, but only a relevant proof of jurisdiction, which would be taken into consideration, but which will not have a final say. Court will interpret the contract based on the facts and in the circumstances of each case. All right. The fourth factor is that in a situation where a court has natural jurisdiction, the court has natural jurisdiction to try the matter, but at the same time, the parties have agreed to submit to, say, exclusive jurisdiction of a foreign court. So what we are looking at here is a contradiction, or a conflict rather, between a court which has a natural jurisdiction, and second, a court to which parties actually agreed to submit the matter before the dispute arose and say that, whenever the dispute arose, we might send our matter to that particular. So that's the forum of choice. In such a situation, court will normally not grant anti-suit injunction. In such a situation, the Indian courts will not grant anti-suit injunction despite being natural jurisdiction when exclusive jurisdiction has been identified by the parties. When we say normally not grant, it means that there could be certain exceptions. Now, one of the exceptions could be that if court believes that if other courts exercises jurisdiction, then that might lead to injustice. Then court can grant anti-suit injunction. Otherwise, generally, in normal circumstances, court will not grant anti-suit injunction in such a situation. The fifth element in terms of issuing anti-suit injunction is when parties have chosen a neutral foreign forum. What do I mean by neutral foreign forum? What I mean by neutral foreign forum is a situation where, say, an Indian citizen and a Brazilian citizen, they have entered into a contract. And they said that, if at all there is a dispute, in future arising from this contract, let's decide not to file a suit in Indian court or Brazilian court. The simple reason being that there might be biasness, or it might be inconvenient, or it might be uneasy for one party to come to the other country and then solve the matter. So courts say that, rather let's have a neutral foreign forum to decide a matter. In such a situation, ordinarily no anti-suit injunction would be granted, mainly because the rationale is that when the parties have chosen a neutral foreign forum, then they should have taken into consideration, say, the aspect of convenience, which is a central defining criteria of forum convenience, and have also thought and might have also thought about other relevant factors. So court will ordinarily not grant anti-suit injunction in such a situation where parties have decided a neutral foreign forum as a forum to solve the dispute. The sixth issue could be that when, say, one of the parties to the jurisdictional clause approaches the court of choice in which, say, the court of choice which was identified in the contract, then the proceedings in that court per se will not be treated as oppressive or, for example, vexatious when the issue of anti-suit injunction comes before the court, or, for example, when the court is deciding the question of forum non-convenience. If something is identified in the contract and the court has for example, contract identifies that a particular forum will have either exclusive or non-exclusive jurisdiction in a particular matter, then mere fact that a party approaches such a jurisdiction itself or per se will not lead to a situation where it can be said that it is a forum non-convenience just because that choice has been exercised. Generally, and when we come to third module, I guess, there is a module called proper law of contract. You will see how various principles in relation to jurisdiction is placed and how court has taken different viewpoints in relation to the issue of jurisdiction. The seventh factor which has to be taken into consideration while granting anti-suit injunction is that when a party claims that the other forum is a more appropriate forum, in such a situation, what is important is that the party which is claiming that a particular forum can be considered as forum non-convenience, that party has to prove the same. So that specific party has to prove the fact that the other forum is a non-convenient forum. Now, moving on, these are the seven factors rather which are important or which significantly define the granting or not granting of anti-suit injunction. So every court has to take into consideration these factors while granting or not granting anti-suit injunction. Now, after this, the very small point which I want to make at the end of the lecture is that how are we going to handle a situation where proceedings in two different courts are going on? How will that work when there is a contradiction? Now, generally, the common law practice to deal with parallel proceedings have been through forum convenience and forum non-convenience. So that has been the general practice in common law countries, that they use or they invoke forum convenience and forum non-convenience to say decide the question of jurisdiction where there are parallel proceedings or proceedings in two courts. Maybe say either refusing to exercise jurisdiction, say that, you know what, we are not the appropriate forum or we are not the convenient forum to go ahead with this particular matter. Or, for example, staying proceedings in courts where say that or for example, they might declare that they are the appropriate forum and therefore they might come out with anti-suit injunction. That has been the general practice. The basic rationale is maybe to reinforce the interest of justice. At the same time, this does not completely eliminate the pathologies of forum shopping. But if there are prior identical or related proceedings, say on 1st January 2020, a Brazilian court was approached in relation to a particular matter, and an Indian court is approached in relation to, say the related proceedings or maybe an identical proceeding between the same party in relation to the same contract. In such a situation, the fact that a prior proceeding already exists would be an important factor in identifying the most important forum, but not a necessary or sufficient factor. This is something which we must remember. The fact that a proceeding is already going on in one of the countries would mean that it is one of the important factors, maybe a very important factor, but not a necessary or sufficient factor in deciding the question of jurisdiction, especially when there are identical or related foreign proceedings and there is a parallel proceeding which is initiated in another country. So this is how we address the question of conflict of jurisdiction. I hope this part is clear. What we try to do today is to complete our discussion on the specific provisions of Code of Civil Procedure and see how the question of jurisdiction is addressed. Now, we will have to look at a number of issues, certainly. One, of course, is that how do we identify the private nature of the entire dispute, whether it is a criminal act or whether it is a civil suit. That is something which we need to see in the first place. The second is, of course, there's not one proceeding which is going on in relation to Vijay Mallya and others. There are a number of proceedings which are going on. Now, if we are talking about, say, the proceedings with regard to extradition, that would be very difficult because that does not come under how we are trying to look at a purely private we are trying to look at a purely private matter. So we will have to see, the defining criteria would be that we will have to see the nature of the dispute in the first place, the subject matter of the nature of the dispute, whether it is say a public dispute or a dispute of a public nature or a civil dispute. The second thing which we'll have to see is the subject matter of the dispute. The third thing which we'll have to see is the parties to the dispute, whether they are the same or the matter relates to the same or the related aspects. And it is in that sense that we will have to identify the foreign element. What is the foreign element involved in that particular case? Not in relation to foreign element of extradition. That would be a question of, say, that would be a purely domestic law question, which with linkages to public international law, but that won't be a private international law matter. That's not a private international law matter in terms of how his crimes are placed and how he is to be extradited to another country to face the trial. That's an issue distinct from what we are trying to find an answer to now. Donika, I hope that part is clear. So that would depend on a number of factors whether it can be considered as an example of parallel proceeding. One is the nature of the suit. Second, the subject matter at hand, the parties to the subject matter, whether there are different kind of proceedings. And then only we can identify, and then we can move ahead to identify the foreign element, and then we can say as to how the jurisdiction is to be understood. All right. So then we further tried to look at three different ideas. One was the idea of forum shopping. We further tried to look at the idea of forum non-convenience, and then we tried to look at the idea of anti-suit injunction. So this is how the fundamentals of jurisdiction are placed. Maybe I'll take 5-10 minutes in the next lecture to brush up your memory or to summarize what we tried to do with regard to jurisdiction. I'll talk about different aspects of private international law disputes. We started our discussion with a very specific aspect, and that is every private international law dispute will have foreign element. Can you hear me?
Yes, sir.
Okay. Thank you. Hey, good morning. Yeah. All right. So then we move ahead and talked about the definition of private international law, and we saw as to how different elements of the definition of private international law are placed. We further talked about in the initial lectures about the different stages of a private international law dispute. Now, once we covered all these aspects, we subsequently moved on to identify the reasons for private international law and why do we need something called private international law rules. Now, in that regard, we focused on a few specific reasons while identifying the distinct nature of private international law dispute. Now, these reasons are that if we apply the domestic law in a dispute involving foreign element invariably, then this might lead to injustice, and we explained as to what conditions this injustice. The second thing is that it might also change the legal status of parties considerably. Further, we talked about the idea of Committee of Nations as the basis of private international law dispute. Now, we saw that while Committee of Nations is generally identified as the basis of a private international law dispute, however, Cheshire seems to disagree with many who argue that private international law or Committee of Nations is the basis of private international law dispute. Subsequently, we also tried to talk about the idea of space and time in relation to private international law dispute. Our argument was that how private international law is significantly different than other laws when it comes to the idea of space and time, and how it breaches the conventional boundary of the application of laws in a given space and time. Further, we talked about the unification efforts in relation to private international law dispute. So we say that how, for example, when it comes to private international law rules, there are different kinds of unification exercises which seems to be happening. Now, these primarily relate to, say, how different rules of private international law are placed, and that few bodies who particularly engage in such a task, UNIDROIT, UNCITRAL, and Hague Conference on Private International Law, a few of them. We further saw that how within Europe, and particularly European Union, the unification exercise seems to have taken a far more sophisticated turn, and the unification among the private international law rules of European nations are better than how these rules are placed in relation to other countries. We further talked about the name of the subject, that is private international law. We saw as to how the name private international law is open to different forms of criticisms. Those who disagree with this name private international law, they propose another term called conflict of laws. But conflict of laws as a term is also open to similar criticisms, and therefore there is no term which comprehensively covers the essence of the subject. But these two are the names which are often invoked in relation to private international law, in relation to private international law rules, and therefore these two terms have acquired a qualified, or for example, or for that matter, an advanced understanding that whenever we refer to, say, private international law or conflict of laws, these terms are so well known that it is understood by those who engage with the subject that we are referring to a particular body of law. Now, having done this in the first week or so, then we moved on to identify and study different stages of private international law dispute. Now, in that regard, we saw that how the question of jurisdiction is placed. We further saw that how applicable law is to be identified, and then recognition and enforcement of foreign judgment is the third stage. We are at the first stage where we were talking about the issue of jurisdiction. In terms of talking about the issue of jurisdiction, we saw that how there could be different approaches to study the question of jurisdiction. We further talked about the general notions of jurisdiction as to what is the concept of jurisdiction, how does public international law conceptualize the issue of jurisdiction, maybe exception to a general jurisdictional debate, and how we tried to talk about universal jurisdiction there. We further tried to advance we further tried to explain the distinction between a purely local matter and a transnational matter. And we saw that how private international law or a transnational matter is different from a purely local matter in which certain kinds of jurisdiction are invoked. So the method of invoking or the framework of invoking jurisdiction in a purely local matter is significant, is different from how jurisdiction is to be invoked in transnational matters. That's one. What we further talked about is the connection idea that every...
दोस्तों, ब्रास फ्यूजन आशा करता है कि आपको हमारा लेसन पसंद आया होगा। कमेंट बॉक्स में अपना फीडबैक देना ना भूलें। थैंक्स फॉर वॉचिंग।